Thank you. Mr. Onek.
Good morning, Your Honors. I'm Peter Onek of the Committee for Public Counsel Services, amicus curiae in this case. Seated to my left is Attorney John Reinstein of the American Civil Liberties Union of Massachusetts, co-author with me of the amicus brief filed in support of Mr. MacDougall's position. Mr. MacDougall, who is pro se, cannot participate in this argument because he is incarcerated. He's a pretrial detainee being held at the Sousa Baranowski Correctional Center in Shirley. There are two arguments, each raising an issue of first impression. In the first, we contend that MacDougall's right to due process was violated when he was transferred from a county jail to a maximum security state prison without an evidentiary hearing and findings of fact by a judge. In the second argument, we contend that MacDougall's transfer while he was still a pretrial detainee violated his right to due process because it subjected him to infamous punishment even though he had not been convicted of any crime.
Can I just ask you one fact question? Both parties are sort of tiptoeing around it. I take it that Mr. MacDougall does not claim that he had not previously been incarcerated for a felony in a state correctional institution. That is a prerequisite under the statute for a transfer.
That is correct. He does not make that claim here.
Okay, so it is waived. It is not. We can view this case with an understanding that all of the other elements are satisfied.
Yes, although that aspect of it is an important part of my argument as to why a Superior Court judge has to give a final go-ahead for such a transfer to a maximum security state prison, because that is a factual question.
But Mr. Onek, if your client, I mean, if the defendant, Mr. MacDougall here, if the petitioner had in fact not previously been convicted of a felony, presumably then a claim would arise and somebody could go in and say, I shouldn't be in state prison because I haven't been previously convicted of a felony, and
that's right.
There's been a mistake, and they would be able to, and if that was contested by the Commonwealth, then I can, as a separate proceeding, I can understand somebody challenging that.
But that's just an example, Your Honor, of a factual question.
Are there any others?
Absolutely.
What?
Well,
presumably,
why is that a factual question? If he doesn't contest that he was convicted of a prior felony, that's the end of that.
yes, Your Honor. In this case, there's no specific contesting of that
right. So
element.
He was convicted of a prior felony.
Right. But if that's
and served a sentence in state prison. Those are the two pieces.
Say that again, Your Honor.
Convicted of a prior felony for which he served a sentence in a state prison.
That's right.
Then the ball game's over, isn't it? Because the statute says you can do what they did here if that factual predicate is found or admitted.
But, Your Honor, there are other factual questions that need to be discussed. For instance, presumably, I assume, we don't actually know why the Commonwealth wanted him sent to the maximum security.
Do they need a reason?
Is that relevant?
Sure they do. Sure they do.
Under the statute? Where in the statute does it say?
Where does it say that?
We say the statute should be read as requiring that because of the constitutional rights involved, Your Honor. There are very serious constitutional rights at stake here. The right to be able to prepare adequately with one's attorney, the right to be near where potential witnesses are.
Mr. Onek, as to that, is there any claim here that he was denied access to his attorney?
No, we don't have a particular claim as to that either. But here's what we do say. I assume that the sheriff and the district attorney wanted to send him off to Walpole and then to Sousa Baranowski because he was allegedly a difficult detainee, that he caused trouble, that there were some allegedly violent incidents. You alone, in your order regarding this matter, say that those are allegations. DOC doesn't say they're allegations. The district attorney doesn't say they're allegations. You alone said those are allegations, and that is exactly the point. What are all of those reports absolutely?
Maybe we misspoke.
I'm sorry, Your Honor?
Maybe we misspoke.
You didn't
Mr.
misspell
Arnott,
it. You were right on point, as I said in my
If it fits
brief.
the statute, it seems to me all this other stuff is irrelevant.
Mr. Arnott, let me make this this point, which is really the flip side. Once he satisfies the statute, the statute says, in essence, it's a question of who can be housed where, and for whatever reason, the legislature drew a distinction between people who had been previously convicted of a felony and had served a sentence in state prison, and one can, hypothesize why they did that. Then it seems to me if somebody has a claim and says that either, which you hint at, look, the conditions in this set of circumstances, as they apply to pretrial detainees, are so disparate from what happens in a county jail. You're not allowed free access to your lawyer, you can't get access to your family, and so on. So this class of people, that's a sort of basic equal protection claim, which it seems to me he hasn't made here. The alternative is to say, I have been moved from prison to prison to prison. I have no prior record of violence, institutional violence. I match the statute. But as a consequence of this, I have lost documents, and then you get into that federal line of cases, communications. The second institution didn't know that Mr. Onek was my attorney and turned him away. I wasn't told that there was going to be a motion to suppress, so on and so forth. Then you've got a particularized record that says that the state is somehow impermissibly using what on its face appears to be, an acceptable statute. And we don't have either one here.
Right.
Do I?
Your Honors, the record is what it is.
Sure.
As you know, I'm amicus.
No, I understand. But we don't. I understand,
we
and
receive
I
the
found
record as it is.
the briefs were very thoughtful briefs, and I appreciate your appearing here today. But we have to decide the case.
What about the fact that the Commissioner of Correction is not a party here?
What is your question?
Well, how does that impact the
It was your
case?
decision to deny. The Commissioner asked to argue today, and the Court.
No, well, it asked to appear as amicus curiae.
Yes.
But it was never made a party below.
Well,
That
we
isn't our
have a
decision.
problem because we've got a pro se litigant.
Yes.
And
Well, pro se litigants are bound to follow the rules, and if our order is going to affect the Commissioner of Correction, who isn't a party,
well, I don't know somebody in the judge in the court below simply looked at the claims that were made, correct, and simply said the Commissioner doesn't have the authority to do this, but the pro se defendant petitioner wasn't in there saying, I've been denied access to my lawyer, even with the broadest possible reading of his claim.
Mr. Onek, if Mr. MacDougall is right, that he is entitled to have a judge make the decision as to where he goes, if he's right about that, the question about his need to communicate with counsel in order to prepare a defense, can't that be handled by motion to have him haved back to either the courthouse or to the local house of correction, to a room where he can communicate with his lawyer privately? I mean, does it really matter where he's living?
That's awkward, but it's more than that, Your Honor. It's access to family, it's access to mail.
Yeah, but
Mr. MacDougall was
okay.
moved about 6 different times, as I recite in the brief.
But the question of his ability to communicate with counsel in order to prepare a defense is, granted that they're all important considerations, that's a different consideration.
Right. Your Honor, that's just another factual question. There are many factual
But why
questions.
does it have to be resolved factually? Why can't that be handled purely administratively between the lawyer and the judge and the defendant as to when he comes up to meet with counsel?
If in the particular case he feels he's being denied access or whatever, he can speak up. And let us say that is so. There are still other factual matters that simply have to be resolved by a judge. That's what judges do. They weigh and balance and resolve factual matters. For instance, the DOC would like you to think that Mr. MacDougall has caused all kinds of trouble. in the jails, and that is why he must be at Sousa Baranowski. Well, we don't know about the truth of that.
Right.
Those are ex parte statements. They are embedded in D reports that you have plenty of in the.
But sometimes the reason for moving somebody doesn't have anything to do with misbehavior. You know, sometimes there are certain combinations of people that simply shouldn't be in the same facility based on, prior gang affiliation or their witnesses in, that sort of stuff. And they look at them and they go, well, one of them can go to state prison and the other one can't, doesn't qualify under the statute. I'm defaulting Judge Spina's question. Part of what bothers me about this is you keep saying a judge has to decide it. Well, when judges have to decide things, there's usually some standard, some measuring yard, measuring stick against which they have to measure it. And here there just isn't one. The reasons why someone might be moved don't necessarily include any accusation of wrongdoing or misbehavior, but have some other features. On what grounds is a judge to approve it or deny it?
The judge is to screen it to make sure that there is a compelling reason why he must be moved, and that's because the presumption is that pretrial detainees are kept in jails. That is Chapter 276, Section 42, which you cited in the Worcester Superior Court case.
But the commissioner has statutory authority to move someone who's in this category, and it doesn't say anything about judges have to prove his discretion in any regard.
Yeah, it could be for something as simple as plain overcrowding.
Your Honor, we agree that the statute doesn't say as much. We say that there are constitutional considerations that trump the statute.
Well, there
that
may
these
be
considerations are so important.
There's none alleged here. They're all just abstract.
No,
I
it
wouldn't
is
be able
alleged
to see
here,
my
Your Honor.
lawyer. I can't see my family. It's all abstract.
Well, let me get to the most important one, the personal safety of Mr. MacDougall. Mr. MacDougall wrote you a letter,
Yes, no, I
Chief
understand.
Justice Marshall. He said, I'm in danger here. Every day I'm here, I'm in danger. Your Honors, I had a client at Sousa Baranowski. You may know that former priest John Gagan was my client at the time he was brutally murdered. That was a very terrible occurrence. It is not unknown in these Level 6 institutions. Murders, all sorts of mayhem. These are nasty, difficult, scary, dangerous places. The DOC's own document that I put in the amicus brief, their own description of Level 6 says these people are a
Do you know
danger.
what his prior
to-
conviction was for?
His prior conviction, I couldn't tell you. I'm not sure it's part of the record. I don't think it's part of the record. But he's not contesting that there was not a prior conviction.
No, I know that.
But what I'm saying is that here is the big constitutional right, besides trial preparation and correspondence and meeting his lawyer. These are dangerous places. He has now been, for more than a year and a half, about a year and a half, in either Walpole or Sousa Baranowski, the two Level 6 institutions. He's a pretrial detainee. He hasn't been convicted of anything.
Why should the conditions of his pretrial detention be the subject of a motion in a criminal case? Isn't that something that should be decided in a civil case having to do with unconstitutional conditions surrounding pretrial
It may be,
detention?
Your Honor.
Because the commissioner may, in fact, have a facility where only pretrial detainees are kept.
Put it this way, Mr. Arnick, that if one attacks the statute on the basis that there are presumptions of innocence, that we provide all kinds of what would be privileges if you were being convicted, and of course are not privileges if you haven't been convicted, and that the legislature has made an irrational determination which can only withstand any kind of scrutiny if there's a showing, for example, that there's severe overcrowding, would be a classic. And in those circumstances, the commissioner has to provide for, as close as possible to the facilities. That I can understand, but that's not this case. That's not this case. I mean, I don't know what the merits of that are because I don't know why. I can think about some of the reasons why the legislature may have said, with a certain category of people who are indicted a second time, if there is overcrowding and so on and so forth, it's permissible to take those people who, put them into state prison.
By the way, before the moment passes, I hope that you'll bear in mind that Mr. MacDougall did not raise the equal protection argument below, but I do in the amicus
No,
brief.
I understand that.
Because
I understand.
it seems to me
Well,
a
I don't-
question crying out for decision. Why should it matter if one happens to have been convicted before of a felony and served time in state prison?
Precisely because of what you just
Why
alluded
should
to.
that-
Namely, he was one of the people who was part of those, what you're characterizing as the more dangerous conditions.
No. Let us say, well, we don't know.
His prior life, prior incarceration, that was where he lived. It is understandable, quite frankly, that they don't want those people who've been exposed to that more dangerous environment, know how it works, in the county jail.
But you know who would also be qualified to go to state prison under the statute would also be someone who, a white-collar criminal, someone who committed tax fraud.
Yeah, but
That person also would have had a felony on his record and been in state prison, and would also presumably be qualified to go to Walpole with the murderers and so forth.
Correct.
Where's the sense in that?
Well, because Justice Sussman's suggestion was that once you are in those kinds of institutions, you learn certain kinds of behavior.
Your Honor, that's...
Mr. Arnott, can you just help me one thing on
Yes,
the
sir.
record? And I understand, I'm not, you hear as amicus, and I really appreciate your, undertaking to argue. There's a petition filed in which he appears to be represented, is represented by counsel, by Mr. Grossman. Was that the petition on which the Judge Dorchakala ruled?
That's right. Attorney Bernard Grossberg represents Mr. MacDougall now on his forthcoming
filed the
trial,
petition.
and
is it
filed
that?
the original motion. That's right, before
But
Judge Dorchakala.
then the handwritten, presumably Mr. McDougall's pro se, were those filed? Were both of those before the judge in the Superior Court?
No. The handwritten materials were not before the judge in Superior Court. All of the Superior Court documents were filed by Attorney Grossberg, who chose, for whatever reason, not to carry on the,
that's
the
understandable.
appellate proceedings from the denial of that motion.
And as I understand, so that's really not before us, the handwritten pro se motion, correct?
Well, the handwritten material, when you say handwritten materials, I think of the materials presented to this court, the 211-3 petition.
That's the 211-3.
Well, that's, yes, but that's, okay.
That's what's handwritten. All of the 211-3 petition and the memorandum, the Rule 221 request.
Well, there is, for example, in Mr. Grossberg's petition, there is an equal protection claim.
Yes.
It's not.
It is not fleshed out.
It's not
quite,
fleshed
quite,
out,
quite
and
as
it really
much as we do.
appears to be closer to the fact that it's a sort of a statutory argument, and it's.
No, it is literally Article 1 and so far equal protection are actually mentioned, but not quite in the terms that Mr. Reinstein and I presented in the amicus brief, which we feel is a compelling and glaring problem with the statute. The white-collar criminal who had a prior incarceration who now goes into Walpole with very, very dangerous people. What's the rational basis for that? And I see my time is expiring, Your Honor. So I would just say that obviously the first argument segues into the second one, that the state prison is infamous punishment. We say Sousa Baranowski is indistinguishable from Walpole, which is officially the state prison. They are the two level 6 prisons. They are the ones that the DOC's own document describes as highly dangerous, inmates dangerous to each other. They say, this is their pamphlet. Mr. MacDougall wrote to you, Your Honor. He said, it's dangerous here.
Yeah.
Get me out of here. I'm here now a year and a half. He hasn't been to trial yet. A year and a half in Walpole, not to belabor the point, these are really nasty, dangerous places, Your Honor.
Well, on many levels, that's troubling.
they're
I don't
very,
have any.
very
I don't
dangerous. A
understand
year and a
why.
half.
I don't understand why that's occurring, and
It
it
is-
should not occur. I
it is
couldn't agree with
troubling.
you more. But if there's a speedy trial issue, that's the context in which that gets raised.
But as Mr. MacDougall says, in response to your suggestion as to whether there might be alternative resolutions to this. He says every day is of the essence here.
Right.
I'm in danger.
I know your time is up. If you bring a civil action, you request a temporary restraining order, you request a preliminary injunction. Those can go very fast. And if it's denied, you a right to take it straight to a single justice. I don't quite understand why the need for rapid action, which I thoroughly appreciate, can't be accommodated within the confines of a civil case. Happens all the time.
Thank you, Mr. Arnick.
Thank you, Your Honors. And we ask that you declare the law in this matter and resolve it. Thank you.
Thank you.
Thank you.
Mr. Wilson?
Good morning, Your Honors. May it please the Court, my name is Brian Wilson, Assistant District Attorney for the Norfolk District, representing the District Attorney for the Norfolk District. The Commonwealth's primary argument is that the defendant has chosen the wrong vehicle to present the issues to the Court, and Mr. Onick's argument with respect to the lack of...
What about the issue of the transfer, though? I mean, he wants to communicate with his lawyer so that he can defend against the case that you've brought. And why, there's that sentence in 52A, the proceedings for such removals, that's the one to the state facility, shall be the same as for the removal of prisoners from one jail or house of correction to another. If they're not what MacDougall says they mean, what's the purpose of that sentence?
Well, I should first say, Your Honor, that what the defendant is saying and what amicus is saying with respect to his lack of communication with his attorney is... But
what does that sentence in the statute mean? Does it mean that whenever there's going to be a transfer out of the house of correction in the county where the trial is taking place, that a judge has to order it? And if it doesn't mean that, what does that sentence mean?
Your Honor, I believe that the practical language, just looking at the language itself of the statute, makes clear that judicial approval is not required in any sense.
So tell me what that sentence means.
If I could just have a moment to review that sentence, Your Honor. It's something that I hadn't considered recently. I apologize. I believe, Your Honor, that sentence refers to the removal of an individual from that state correctional facility back to a house of correction in order to effectuate the actual trial process, and for convenience purposes, allowing the transfer of a pretrial detainee to a more convenient place in order to in other words, so that if someone is being tried in Norfolk County, that they're not being held in some other part of the Commonwealth that would inconvenience the transportation of that individual on a daily basis for a trial.
Mr. Wilson,
I understand your argument about a different, perhaps more appropriate vehicle, but is it the case that this person is being held in the general population of the state prison? Not in a pretrial section or unit or somehow kept separate from?
The only thing that's clear, Your Honor, is that the defendant is, first of all, not in state prison. He is in a state correctional facility that is not a state prison. There is only one state prison, and that's established by the legislature. That would be Cedar
Trust
Junction.
me, I'm not going to get hung up on that. This is the maximum security prison, the one of two. Tell me, answer the question if you can. Is he held in the general population?
The shorter answer is that I cannot answer that question because it's not part of the record.
I understand that.
And it
But
wasn't
doesn't
part
it one of the
record.
problems of not having the Commissioner of Correction and the Department of Corrections in this proceeding? We know nothing about these things. I assume the District Attorney's Office has no involvement in that part of
None whatsoever, Your
what
Honor.
happens to him.
That's
Yeah.
the Commonwealth's primary argument, that the defendant's chosen the wrong vehicle. And it's not simply a technicality that the defendant has alternative remedies available to him. It's for a practical matter, because all of these issues with respect to where he's being housed, the differences between his current incarceration status and any incarceration status he would have at the House of Correction as a pretrial detainee, whether he has access to his attorney and family and so forth, whether those inconvenience him or somehow even in a more important sense affect his right to present a defense at his trial or trials are simply matters that are not part of the record before this court and were never a part of the record before the trial judge or the motion judge who decided this case in the first place. What this was a very brief hearing, not even an evidentiary hearing, and based upon the nature of the arguments that were presented by the defendant at that time, which essentially focused on the statutory language itself. Does the statute allow the district attorney to simply approve this transfer, or is there something more involved, the approval of a judge? That was really the only issue presented by counsel.
What I do have, okay, I have a statute, and which was in effect at the time that 27652A was enacted, that says persons committed on charge of crime shall not be confined with convicts, correct? So presumably the legislature is saying keep the two separate. Then I have a claim, as I understand it, that he was transferred to Cedar Junction, okay, from the Norfolk County House of Correction, and since that date he had been incarcerated in Block 10, the disciplinary unit of MCI Cedar Junction. I take it that he's with other people, convicted people in that unit. I mean, this is not a pre-trial. And then he was transferred there to the Dedham House. I mean, he's bouncing all over the place, correct?
Yes, Your Honor. Whether he was ever or is at this point housed within the confines with other convicts is something that, again, I can't speak to as simply a representative of the district attorney.
It's not in the record, so we don't know. I mean, the record is just full of all these holes.
Does the judge know where this guy is? Do any of the judges in Norfolk County know where this guy is?
Absolutely. Because
how do they know?
Because every time that he's due to appear in court, which is almost on a monthly basis, Habe is sent to that facility.
But how do they know where to send the Habe? Because the minimus doesn't reflect where he is. The minimus says he's in the Norfolk County House of Correction.
I'm sure at some point his attorney, at least on the record, had told the court that next time the defendant's to appear in court, we need a Habe to a particular location, and that location is, at this point, Sousa Baranowski.
Do you have any idea when his trial may be coming up? Is it scheduled yet?
It's not scheduled yet. We are awaiting the decision on a motion to suppress and a motion to dismiss. We've been waiting quite some time. It appears that there would have to be two trials.
Has there been a hearing on the motion? It's under advisement?
Yes, it's under advisement, and that only deals with the defendant's initial case, which dealt with his threatening to blow up his mother's house. And then, of course, as I've noted in my brief, while he was in the Norfolk County House of Correction awaiting trial on that charge, he committed several offenses, including mayhem against a corrections officer, and that would certainly be a separate
On the motion
trial.
to suppress, motion to dismiss, was there an evidentiary hearing?
Yes, there was, Your
And,
And when was that?
How long has it been under advisement?
Honor. I would estimate roughly 3 months or so.
And where's it pending? Which court?
In Norfolk Superior Court.
Now, it's not in the record what his previous felony conviction was for, I take it.
It is not, Your Honor. It was not an issue below. He did not even...
He conceded that that's so many words, that he met the statutory requirement.
Yes, Your Honor. And in approving the request by the Department of Correction to transfer him in the first place, the district attorney typically, and I know for a fact we did in this case, would review the inmate's record to ensure that the person does in fact qualify under the statute, and this individual did.
Mr. Wilson, you said that he had chosen the wrong vehicle. From the Commonwealth's point of view, what's the correct vehicle?
The correct vehicle will be a civil suit against the Commissioner of Correction, who is an essential party to this matter. And in that case...
Well, to sue, I assume, the district attorney, because, the Commissioner of Corrections would come in and say, it's got nothing to do with me, I just get the person and I do the best that I can. Isn't that the Commissioner's point of view?
Well, not exactly, since we held in the Worcester County case that the Commissioner has to agree.
Yeah, in fact, it's the Commissioner's, as I read it, it's the Commissioner's decision, but he has to have the approval of the DA in order to do it.
That's correct. And the approval of the district attorney, I can speak of as a practical matter. I don't want to call it a rubber stamp. It wouldn't be fair to call it a rubber stamp. But essentially, it's a check on the power of the Commissioner of Correction, and the role of the district attorney is simply to make sure that the individual does, in fact, qualify under the statute. But as this Court noted in its recent decision, the Commissioner of the Correction herself is the one who's in the best position to decide if certain individuals, for safety reasons or overcrowding reasons or escape risk reasons, really meet the requirements of the statute, and would it be practical to transfer that person?
He said, this guy's not under sentence. He's actually, his body is owned by the court because the court decided to set bail, and he hasn't posted the bail. And of all the people in the process who don't know where he is, at least in terms of a paper trail, it's the judge. There's no piece of paper that says, there's no piece of paper filed in the court that says where he is.
I would have to review the record, Your Honor, with respect to any habeas that is sent to an institution in order to bring the defendant to Norfolk Superior Court. I am not aware of any instance in which the defendant was housed at Sousa Baranowski and for whatever reason had no difficulty being transported to the Norfolk Superior Court.
Is it fair for me to infer that he was at Cedar Junction and there was a straight-out attack on that because he shouldn't be at Cedar Junction, he should, not be in state prison, and they moved him over to Sousa Baranowski as the highest security within the non-state prison system?
Your Honor, I couldn't address the...
I mean, all of a sudden he's in Cedar Junction, and then he's out of Cedar Junction, then he's back in Sousa Baranowski.
I simply can't. We have no record to determine, and as a representative of the district attorney, I'm in no position to enlighten the court as to why he was put in one institution and then moved to another, unfortunately. And if the
I take it, though, from the district attorney's point of view, the district attorney simply says the sole check that the district attorney exercises, and I'm not suggesting that the district attorney should be doing anything else, is to say, has this person previously been convicted of a felon and served some or all of his sentence or her sentence in state prison? Correct?
I don't mean to suggest that nothing more goes into the determination of whether it's a proper transfer, but that certainly is the check placed upon the power of the Commissioner of Correction.
The Commissioner, I assume, for any reason, could deny approval, saying we want this person here, readily available, for a whole bunch of reasons. So, I mean, there's no limit on why the district attorney can not give his or her approval in the statute.
That's correct.
But this is a qualifying factor, which, of course, the district attorney would want to confirm.
Yes, Your Honor.
But would I be correct in understanding that if the district attorney were doing anything other than making sure that he's technically satisfied the statute, he's a previously convicted felon serving time in state prison, that the district attorney nevertheless feels that in his or her discretion they can take a look at why this person is being transferred?
Absolutely, Your Honor. The district attorney has the power to request of the Commissioner of Correction the reasons for the transfer. And if for whatever reason the district attorney feels in his determination that it would be a transfer for an improper reason, with all of the deference accorded to the Commissioner of Correction, then the district attorney can simply refuse
Well, there
to
seems to be
approve the request.
no boundary on why the district attorney could refuse to approve. Might want to refuse to approve because they think they're getting close to convincing this particular guy to work as an informant.
That's true.
And doesn't even want to share information like that with the Commissioner of Correction. Can just go, no, we want him kept here.
It seems like an odd person to vest this this sort of impartial check is the district attorney. The district, I mean, at least the appearance of conflict is pretty strong. The district attorney doesn't want this guy to communicate with his lawyer.
The district attorney is charged with the responsibility of every single day determining whether to charge certain individuals with crimes and with which to charge them if the determination is appropriate.
Why isn't a judge in a better position to make that determination than the district attorney? If you were going to have anybody make this decision, why the district attorney?
Well, the legislature has determined that the district attorney is in the best position to make that determination.
Well, no, even the commissioner can make the determination. The district attorney simply has to give his, quote, approval. And without his or her approval, the commissioner can't move the person.
Well, the commissioner is in the best position, as this court noted, as I've already mentioned, that the commissioner is in the best position and has the expertise to determine why a certain individual should, in fact, be moved.
And doesn't the commissioner also, the commissioner certainly has access to the person's prior record, knows just as well as the district attorney whether the prior felony and sentence to state prison has or has not occurred.
Absolutely.
So I don't quite follow why you are characterizing it as sort of the district attorney's job to check that. Maybe the district attorney does, as a practical matter, want to make sure that's okay, but as I see it, the approval or disapproval can be granted or withheld on any reason the district attorney chooses.
The legislature has determined that we don't really have a reason to determine why a judge would be in a better position than the district attorney. I know Mr. Onek has basically argued that the district attorney is someone who has an axe to grind against this inmate for whatever reason. But the legislature has determined that the district attorney, who is responsible for prosecuting crime in Norfolk County, has the opportunity and the responsibility for making the same determination perhaps that a judge ultimately would.
Well, it's the district attorney who would, for example, know things like, oh, you're moving him to a place where an important witness in another related case is, and we don't want them in the same facility.
Certain.
Commissioner might not know that. Judge certainly wouldn't know that. Only DAs would know that.
That's correct.
So again, I don't understand why you're saying that this is done as a, quote, rubber stamp, or why the only thing that goes into it is whether he satisfies the statute. I would assume there are other things going into it.
Well, there may be other things. What happened in this particular case, I can't enlighten the court as to why that determination was made to approve this transfer. I'm assuming because this office has prosecuted this particular inmate any number of times, and I don't want to stray from the record, but this office was in a position to determine whether the reasons for transferring this person, which had to do with his violent history, were in fact true and were in fact did in fact form the basis for an appropriate transfer.
Well, when you get into appropriate transfer, you're getting into territory I don't think you want to get into. If it's appropriate, well, maybe a judge does make that decision. Maybe there has to be a specific reason.
Well, there's nothing on this record to show it was inappropriate, right?
No, there's not.
Well, except that he claims that he hasn't been convicted and he's incarcerated for a lengthy period of time in a maximum security, which I think by definition we can recognize as. I mean, in other words, if the claim which the commissioner has spelled out quite forthrightly in an amicus brief appears to be a security-related claim. Let's assume that you have nothing like that. For some reason, somebody who was convicted of felony, served time in state prison, is held in the House of Correction and suddenly finds one morning that he or she has been taken over to Susan Belanowski, whatever it is, and is in the disciplinary unit. I suppose your response to that is file a civil action.
Because the defendant's claims are, there's no avenue for this court to test those claims. The defendant's claims are made in paper.
No, I understand that, but the question, if you read the statute appears to say, and that's just the import of Justice Cordy's question, unless that petitioner may not be able to demonstrate that he has been denied access to counsel. All he's saying is, I'm here. I don't understand why. And the answer would be, as far as I read the judge's ruling, which might be perfectly appropriate, I don't have to inquire into that. because there's no claim that you don't satisfy the statute. So anything beyond that doesn't require any kind of inquiry from the judge. I mean, he was saying, I'm in this high-security place, and I should be in a house of correction.
Well, in that sense, then the statute, 52A, may have been complied with, but there's still the avenue of a civil suit against the Commissioner
And what's he
of
going to say
Correction.
there? If he can't say anything other than, I was here and I'm now there, and judge, I shouldn't be there because there's no reason for me to be here and it's very dangerous. He's not making a claim as I don't have access to a lawyer. He's not making a claim that anybody's picking on him. He's simply saying, I'm talking about, not Mr. MacDougall, but the same case presented on the same facts, which is all that the judge had in front of her. I shouldn't be here. I shouldn't be moved from there, from a house of correction to, it was then Cedar Junction, now it's Varanowski, without somebody explaining to me why I've been moved.
He has no right to that. He can't bring any claim because the statute says if these conditions are complied with, he's moved. And then anything beyond that, whether he's dangerous, couldn't talk to his lawyer or anything else, the burden's on him to file a civil action. He has no claim.
If in that sense he's claiming that he has in fact been punished as a pretrial detainee by this transfer and by his new conditions, he could file a civil suit and address those claims and flesh out those facts that would form the basis for this.
Yeah, a due
for this
process
claim.
claim, an equal protection claim, whatever, but the claim has to be founded on something. It has to have a theory, in other words, of what's been violated.
Well, he said this is a form of punishment. I mean, it was very clear. This is a form of punishment. The conditions here are a form of punishment. And the judge essentially said, I don't look at that. And he said, I'm being punished. These conditions are very severe. I'm being punished. I haven't been convicted. I'm being punished.
Well, then he has to bring that in a civil action.
Well, the form that this defendant has chosen doesn't allow this court to determine whether he has in fact been punished, because we don't know whether he's really in a different practical position being at Sousa Baranowski than he was at the House
No, but
of
the judge
Correction.
said, I can't examine that question because you just meet the statutory definition. Shouldn't she have said, well, let's hear from the commissioner why you were moved?
Well, the judge in this case below.
Why is that relevant, why he was
Criminal
moved?
action, yeah.
It's clearly irrelevant.
The judge in this case below wasn't even asked to address the constitutional ramifications of this transfer. It was simply a matter of, was the statute complied with and is judicial approval necessary?
If you look at the statute doesn't ask anything about why you moved or reasons. It's obviously, it seems to me, it's just an administrative statute. If the Commissioner of Correction needs to move people around, he, she can do so, and there's, in some cases, oversight by the court, and there's the oversight by the DA, but it seems to me that much ado is being made about nothing.
Because the way that the legislature has worded the statute is obviously in deference to the expertise of the Commissioner of Correction, who is in the best position to determine whether a transfer is appropriate. I see my time is up.
Thank
If there
you,
are no
Mr.
further
Wilson.
questions, I recognize you. Thank you very much.